We've talked about what's necessary to do and preparing your claim of lien and then filing the claim of lien and then filing the suit. Let's talk a little bit about negotiating that claim of lien before you have to go to trial and spend all that money on attorneys.
Another negotiation strategy is litigation, right? Because you can tell a person in a demand letter, if we don't settle, we're going to file a lawsuit, but nothing makes the message more clear than filing a lawsuit.
Hello, this is Chip Beshara with Beshara Construction Law Group, a Florida law firm with offices in Jacksonville and St. Petersburg. And with me today is Hugh Higgins, managing partner of the St. Petersburg office. Hi, Hugh.
Hey, how's it going, Chip?
I'm doing good. Hugh, we've been talking about claims of lien and how contractors, subcontractors, and suppliers can protect themselves when they're not paid for their work or their materials that they provided. We've talked about what's necessary to do and preparing your claim of lien and then filing the claim of lien and then filing the suit on the claim of lien. So let's talk a little bit about negotiating that claim of lien before you have to go to trial and spend all that money on attorneys. What are some good suggestions for strategy of negotiating?
Well, one that I think is a good one, just as a starting point, when you record the claim of lien, the statute requires that you serve that recorded claim of lien on the owner. So in the process of doing that, that's a really good time to serve a demand letter that encloses the claim of lien that lets the owner know, hey, we've recorded a claim of lien against your property. Your property is now encumbered. You can't sell it. You can't refinance it until you deal with this lien. And, oh, by the way, we're entitled to attorney's fees, and we've already incurred some to prepare this claim of lien. But now's your best opportunity to settle this, because now if you settle it, the attorney's fees are relatively minimal. We haven't filed a complaint yet. We haven't taken depositions. We haven't done the whole litigation thing. So let's go ahead and resolve this.
I think the likelihood of success of that early demand letter depends on who your target is, who's receiving it. If it's a sophisticated owner that has been through the process before and they look at the claim of lien and they realize, this subcontractor hasn't been paid yet and they did good work. I don't have any complaints about them. I'd like to get this subcontractor paid. That's something that it's likely to happen. It's less likely, in my experience, to happen between a contractor and an owner because there's probably already a dispute brewing there. But it is always early to send that, always a good idea to send that early letter because it can come into play later on in the litigation. Let's talk a little bit, Hugh, about attorney's fees and the recoverability of attorney's fees. I think we have what's called the American rule, and we've talked a little bit about this before. And the American rule is that each party bears their own attorney's fees and costs for any type of litigation, unless there is a written provision in a contract that says the prevailing party or one party or the other can recover their attorney's fees in the event of litigation or arbitration, or if the statute allows for the recovery of attorney's fees. If you don't have one of those two things, and then there are some exceptions when there's consumer rights involved, but if you don't have it in your contract, or if it's not in a statute that you're going to be pursuing it under, then everybody is spending their own money on the fight. One of the things that the lien law does is it gives the contractors, the subcontractors, and the suppliers a little extra leverage by saying, whoever is the prevailing party, it could be the owner, but whoever is the prevailing party is entitled to recover from the non-prevailing party, the loser, the reasonable attorney's fees that have been incurred. And so that can very quickly become the driver of the settlement negotiations. And so that's something you want to be aware of and be careful of, because it is not unusual if someone has filed suit on a $70,000 claim of lien and the owner decides they're going to go to the mat fighting it, it's not going to take very long at all for the attorney's fees to quickly exceed the $70,000 that's being sued over.
Another negotiation strategy is litigation, right? Because you can tell a person in a demand letter, if we don't settle, we're going to file a lawsuit, but nothing makes the message more clear than filing a lawsuit. And settlement and negotiation is all about what the other side is motivated by. Some owners are just not going to pay unless they are, legally and properly backed into a corner and forced to pay. And they realize, okay, I don't want to be in court. I don't need to be distracted with this. I don't need to rack up a bunch of attorney's fees on my side and potentially have to pay for their side. Let me figure out what's necessary to make this go away. And then the parties are in a posture to negotiate and get to a reasonable point of agreement.
Well, so far we've mostly been talking about situations where the owner has the ability to make a payment or to pay for the work that's involved. Let's talk a little bit about a situation where, let's say the owner has gone bankrupt or they've abandoned, they can't pay for this project anymore. Is it even worth recording the claim of lien if you know there's nothing there to be paid? And one thing I'll tell you from my experience is absolutely record your claim of lien, because there is going to be at some point some fund of money. And having been on the owner's side of this as well, when you go down and you look at everyone who's owed money, the next thing you do is find out who has recorded claims of lien and which of those claims of lien are valid. And you look at the valid claims of lien and you figure those are the people that have to get paid. If they messed up on their claim of lien or they didn't file a claim of lien, it's as if the amount that's owed to you is zero. And so it's really critical to get that lien filed and make sure that it is an accurate claim of lien, because you never know what's going to happen financially to that owner or to that property. That it may wind up getting sold or in a foreclosure situation, and you want to have your lien rights protected.
Absolutely. Even more so, you want to protect your lien rights if there's a bankruptcy situation or the threat of one, because you want to be a secured creditor and not an unsecured creditor. In the same way that no one's giving out car loans without using the car as a security.
And, there are certainly steps you need to go through. If the owner is going through bankruptcy, you're going to want to get with an attorney that knows those rights and how to make your claim of lien a secured claim, because there are other steps that we would have to go through, but you do want to be a secured creditor and not an unsecured creditor in that process. Now, Hugh, you made reference a while back to some other either defenses or offensive positions that an owner might take, such as defective work or incomplete work. Let's talk a little bit about how those can affect your claim of lien. I mean, certainly that's going to create a challenge to the amount, right?
Yes. And ideally, you have those conversations at the outset, even before you file a claim of lien, and certainly before you file a lien foreclosure complaint. You have those conversations with your attorney.
They'll sit back. The owner will start to collect the list of items of things that they're going to complain about, and invariably it will be just more than what your claim of lien is. If you lien the project for $125,000, I can almost assure you the value of the owner's claimed defects is going to be $130,000. So they want to get it beyond that for negotiating purposes. And sometimes that's just the MO of the owner. That's just how they do business. And so, we see that sometimes, and we know there are ways that we have to battle around that. But sometimes those are the things that you have to go through. Now, there are situations where a contractor in particular is usually required to defend and indemnify an owner when a lien is recorded. And one of the things that a contractor can do or the owner can do is remove that lien from the title of the property because they may want to sell that property, and they transfer it to some type of bond. And Hugh, let's talk about how that impacts litigation if it's transferred to a bond, for example.
Yes. So for contractors that are familiar with payment bonds during the construction of a project, it's a lot like that. If at any point in time a claim of lien is transferred to a bond, then that 1-year lawsuit clock resets, and the contractor now has to file a lawsuit against the bond, against the surety company, just as they would against the owner. And so now the claim of lien essentially turns into a claim against the bond, and you have 1 year to file your bond foreclosure complaint. Otherwise, you lose all your lien rights and your bond rights.
There are a lot of complications involved, as we've talked about now, in the lien law. It is considered one of the most complex laws on the books in the state of Florida. I think what the lesson here is when you're in a situation where you need to protect yourself from getting paid for your payment and to recover payment, and you're not allowed to go and take back the work that you've done. If once it's incorporated into the property, you cannot do that under Florida law. That's a good time to call a lawyer and evaluate. Make sure the lawyer is evaluating the economics of the situation for you. We do that with every phone call that we receive, and we talk about the amount in dispute and what it might cost to do that. And I think it's important that happen. If you find yourself in that situation, give Hugh or myself a call. We'll be glad to help you out and get you set on the right track for recovering that payment. Thanks very much.